Hey guys, criminal defense attorney Ryan Pacyga, and today I want to give you a little bit of a story about going the extra mile. In Minnesota, if you get 4 DWIs within a 10-year period, it'll be charged as a felony. And there's a statute that says that if you get this felony charge for a DWI, you can't get a non-felony disposition. In other words, it's got to be a felony, right? And they've also got some mandatory jail parts for that as well, okay? So he had qualified priors, 3 prior DWIs within the 10-year period. This was his fourth, and so it seemed like an open and shut case in terms of him not being able to avoid a felony. The police had done their job in the right ways in this case. They had a reason to pull him over. He had an open bottle in the car once they saw him. He tested over the limit. So it appeared on some cases, at least, to be an open and shut case in terms of it wasn't a case that he was going to get thrown out, and it wasn't a case that he was going to win at trial, right? Well, wait a minute. Knowing that, I go to the prosecutor and I say, hey, I don't want this guy to have a felony. He's got child support he pays from another relationship, and he's got a new girlfriend, and he's helping raise her child, right? The prosecutor says, well, there's a statute right here saying that you can't get a non-felony on these kind of cases. It's the law. I said, okay, well, let's see about that. So get the guy into treatment. He does really well in there, and that's a good thing. But there was something else about him, and that is that he had some mental health issues from before. I mean, not to the point where he doesn't know what he's doing, but we did a deep dive not only into his treatment part of it and got him help with that, but in addition to that, he was in therapy, and we got his prior therapy records, digging back for years, and my assistant and I went over those, and we used what's called the DSM-4, by the way, which is a psychological book that talks about the diagnoses of different psychological conditions, if you will. And one of the diagnoses he had actually indicates that people with this diagnosis have a higher rate of alcohol or drug abuse, as well as they have a tendency to be very impulsive, okay? And there's some decision-making questions with people with that kind of diagnosis. Not all of them, but it can play into it, right? When we got these records, and my assistant had pulled up some psychological studies on this particular diagnosis as well, and when I read through that, we decided to put together a really solid letter for the prosecutor with the research in these psychological articles citing to this type of condition that he had. And I was basically telling the prosecutor, listen, this client of mine, he doesn't start from the same place as most people do, right? He's got some of these deficiencies, if you will, and these are things that he was born with and that continue to trouble him. And so I don't quite think it's as fair to hold him as accountable as someone who doesn't have these sorts of conditions going on. I mean, the literature is right there about these higher incidents of alcohol abuse, as well as some decision-making issues that these people have. And I said, because of all of that, and because he's been doing well in treatment, I think that you should consider a non-felony here for him. And the prosecutor eventually ended up hearing me out on it, and this was a long push. I mean, the case has been going on for at least 9 months, and we were hearing no's at every turn, including no to getting into DWI courts in many counties because he wasn't a resident of those counties, which can be a problem, right? So I'm happy to report that through that extra work we did in digging deep through the psychological records and then going into studies about this particular condition, we could put that all together and advocate for him and say, hey, you might have him cornered and legally in terms of if he goes to trial, we're not going to win the case. However, is that the right thing to do to this person here? Because if he gets a felony conviction, he's going to lose his job. He's not going to be able to support this other boy he's supporting now and pay child support on the other case. And what are his prospects going forward, right? So he's still got to stay sober. We got what's called a staggered sentence, which means that he's going to have jail time hanging over his head on probation for 4 years. And on the anniversary of the sentencing date, we've got to file a motion and show that he's been sober for that year each year. And if he is, he'll be relieved of 75 days of jail each of those years. But if he's not, he'll do jail that year for 75 years. But regardless, he's going to avoid a felony disposition here. And then in addition to that, he'll have to be on a breath monitor once over the holidays for a month each end of year between Christmas and basically the middle of January to make sure he's not drinking as well. So there is some accountability that has to go with that to make sure that he continues to do well. But that's sort of trying to go the extra mile there and pushing the envelope and advocating, hey, this is a guy that's got some conditions that many of us don't have to struggle with. We should take that into account. Let's try to be creative and find another way to achieve what the prosecution's concerned about is, hey, he's had priors, he should be punished. We got it, nothing else is working to deter him. Well, now with this creative staggered sentence that we were able to get, and the advocacy that my assistant and I were able to do with respect to his mental health issues, we were able to get a result that I think was much more fair under the circumstances and took into account his life history and what he's got going on as well. I'm criminal defense attorney Ryan Pacyga. You can find me at arrestedmn.com or call me at 612-339-5858.